All right. Again, good evening. This is Mike Pissarro. I'm the Policy Director for the Watershed Institute. I want to thank you for joining our webinar, How to Become a Voice Before Your Land Use Board. We have a group of panelists, and what we're going to do today is more of a conversation than presentations. So if you have questions, there is a question and answer box. Please pose those. Everyone other than the panelists should be muted, so you can't vocalize your questions, but please post them. We will address them as we can. All right, so just a couple housekeeping again, questions and answers. There's a chat box. If you have some issues, please email us and we will try to help you. Also, there's a chat box. If you see that, you can reach out to Priscilla or myself and we will help you. We are recording this presentation and we will have it up on our website within a few days after we finish tonight. So with that, let me introduce our panelists. We have their full bios on our website, so I'm not going to read their bios in detail. But we have Michelle Donato, who's a land use attorney. She currently represents planning boards in the city of Plainfield and the boroughs of Shrewsbury and Roosevelt, and she's special counsel to several municipalities. She represents environmental groups and municipal agencies. We have Mary Lou Ferrara. She is currently the Hopewell Borough Planning Board member, but has been on the Hopewell Township zoning and planning boards. We have Jim Kyle, who is a professional planner. He has served on the staff of the Hunter County Planning Board in Flemington. He's currently appointed as the consulting municipal planner in Bethlehem Township in the Township of Clinton and Franklin and Oxford Townships, and a planning consultant for the Zoning Board of Adjustment. And then Dennis O'Neill, he is a retired engineer, but was the Hopewell Borough engineer for many years. And both Dennis and Jim have helped the watershed out in the past for various projects we have done. So welcome very much. And also, this is a new platform we're using, Zoom. So if people have any feedback on that, please let us know. So with that, what we want to do is talk about what happens when you find an application, a development proposal in your town, in your neighborhood. What do you do? How do you do it? What's the best way to approach it? So one of the first things really is, how do you find out that a project is coming to your town? And one of the ways really is either a newspaper notice. And so you should see up here a copy of a newspaper notice for a project that we're actually involved in right now. This will show up in your local newspaper. Each town has their official newspaper. And then sometimes if you're within 200 feet of that project under certain circumstances, you may get a certified piece of mail with this notice, something very similar from a law firm telling you that. So, this may be your first notice that something's coming. And this comes out ahead of the hearing, but it has to come out and please correct. Thank you, Mary Lou. Yeah, at least 10 days before the hearing. The certified mail that you may get may not get there until the day of the hearing, because they have to mail it out 7 days ahead of time. 10 days. So they have to mail it 10 days. That doesn't mean you have to receive it 10 days. So you will see that. Other times you may not see this in the newspaper, but you may be looking at your town's agendas. And those come out several days before a meeting, and other times they come out the day of the meeting. So, and this is just a sample. This is from the Princeton Township. This is a agenda. It will tell you Princeton Planning Board, Thursday on May 7th. It will give you the information. We are in a new world, so all these things are now virtual. They will give you the agenda. And this, this may also be your first notice that something is happening. So panelists, I'm going to open it up. Someone gets this notice, they get it by mail, they see it in the newspaper. What should they be looking for? What should they be thinking about? Going from there, just sort of very broad brush. You see this notice, what sort of should be those next steps that come into someone's mind? Now I'll open it up to the panelists.
I'll start on that one, Michelle Donato. So the notice is almost something that you don't really want that to be the first time you learn about the proposed development, because as Mike has pointed out, that notice is mailed 10 days before. You as a property owner may not even get it from the post office until a few days before. And a lot of people ignore their certifieds and don't sign them. So you really have to have a very constrained time frame. So, and very short period of time to respond. Generally speaking, a board will not allow objectors or neighboring property owners to get an adjournment of the proceedings simply because they didn't get the notice 10 days before, or they're not prepared, or they don't have an attorney or witnesses. It's a very difficult position, and there have been efforts to change and expand that 10-day time period, but they have fallen on deaf ears for many, many years. So you've got to really be prepared right away. And you look at the notice and you'll see that it will be either before a planning board or a zoning board, unless you have a board that is combined, because it is possible in certain smaller communities to have a combined planning and zoning board. But the nature of the variance is very significant, because you want to be able to know, is this in accordance with the zoning? Does it meet the use standards? Does it meet the density standards? Or is it something that requires what is called a D variance, which within a D variance, there's a use variance that could be sought. So that's number one. What is it, and how serious is this? And the second question is, are there other variances, what are called C variances, where the use might be permitted, the density is acceptable, but it doesn't meet setbacks or things of that nature? And it makes a big difference. So look at that notice, know where the property is, and think, this is what's going on here. It's going to be a 7-story building or something. You want to know what is being proposed, and you really want to scrutinize the notice, because notice is what we call jurisdictional. So if the notice is wrong, the application doesn't get heard.
And can I just quickly add, Michelle, in that variance, as you're reading what might be proposed, you might think, well, that doesn't look so terrible, what they're suggesting, but often at the bottom of it, it will say something like, and other such variances or relief as the board may deem appropriate. So you don't even necessarily know everything that could occur unless you show up at the meeting.
Absolutely. You should show up at the meeting. Absolutely. Well, the first thing you should do is go down to town hall and inspect the file. You may not have enough time to do so. That's a general problem, but you need to really look at the plans and see what is being proposed. The nature of the use must be described in the notice. So that those catch-all provisions about any other variances and waivers that may be required will be sought. There aren't too many cases addressing that issue. So my thought has always been, they can't change the nature of the use. So, but there's a lot of other things they could change. Mary Lou is absolutely correct.
So let me just step in a little bit. I'm starting to highlight a few things on this notice. As you hear, this is an application before the planning board. So that means certain things. And Mary Lou, in a second, I want you to talk about the planning board and zoning board. As Mary Lou and Michelle talked about, what does the applicant want to do? They want to subdivide the subject property to allow for construction of 174 single-family homes, accessory clubhouse, recreational amenities, and other supporting infrastructure. The other thing is, to know is, where is this? So they'll do it in two ways, the applicant. They will give you a lot and block, which I've now highlighted. They will also give you the mailing address. Got to make sure these things are right. They will then tell you, in essence, the application does not request any variances, exceptions, or waivers from the applicable provisions of the Cranberry Township Zoning Code. So Mary Lou, you
Right.
get an
So,
application like this. This is going to the planning board.
right. So that's a planning board application, and it doesn't have any variances because the zoning board of adjustment, except for in little towns like Hopewell Borough, where we have a shared board, is the one that deals with variances. So usually a planning board application is not as surprising or perhaps scary for the neighbors because it's already going to generally comply with the current zoning. Planning board applications are generally more ministerial, that the board just reviews it to make sure that everything is in compliance. But you can still go, and if you're concerned about the application, you should still go, because you can get a lot of improvements to the application, often simply by asking. If you say, would the applicant be willing to increase their buffering with trees and holly bushes, or whatever it is that you think would help to make the application less detrimental to you, most of the time, if it's reasonable, the applicant will agree to it just to get through the application, and the board will make it part of the requirements that that they've agreed to it. It's going to be in the resolution that that applicant has agreed to it. But the zoning board is where the real action is, and where you really need to show up if there's a variance at a zoning board, because that's where something that normally, when you bought your house, that 7-story building wouldn't be allowed in a residential neighborhood next to your house. Or as in recently in Hopewell Township, a lot of people probably remember the CVS application to build a CVS in a residential zone. People didn't think that that was something that would ever happen in their neighborhood, so they were happily living in a zone where there was no CVS. So there you need to respond. And as Michelle said, best case scenario, you have 9 days to figure out what you're going to do, right? I mean, 10 days, theoretically, you could get the notice in 10 days, but you're not going to. So you have 9 days to figure out how bad it is, put together maybe a group of neighbors to help you figure out what you're going to do. And my honest advice is, if it's something that you really think is detrimental to your neighborhood, get a lawyer. You are at a disadvantage as the neighbors. This group has already put together their application. They have professional planners, engineers, every kind of environmental consultant they need. They're ready to make their case. And unless someone shows up with some pretty decent ammunition and pretty experienced attorneys, and in the case of a variance, a planner, because they're going to have planning testimony saying that this absolutely, we'll probably address positive and negative criteria later, but that this meets the positive and negative criteria, you're going to need somebody to come and give expert testimony that contradicts it. So I'm not promoting like full service, full employment for lawyers, but I do think in the case of a variance that you find distressing, hire a lawyer.
As a lawyer, that's not a problem. But there was a question in the chat. I just want to make sure everyone saw that. The question really is, do the legal notices need to be published on the town's website? The legal notices themselves are not published on the town's website. That is something the applicant does. They submit it to the newspaper, they mail it out. Your town, in the municipal agenda, So the planning board or the zoning board's agenda, which can be found on the town's websites, will have, you know, an application that is being scheduled. You may have less time than looking at the newspaper, because those sometimes come out the day before, 2 days before, 3 days before. So I want to unpackage some of the things that Mary Lou, you just talked about. We talked about variances, planning boards, zoning boards. So an application before the planning board, by and large, is an application that meets all of the standards that the township has set out. That is an application for single-family homes in a zone that is zoned for single-family homes. That is an application that has, you know, the lot coverage and the setbacks, so how far that development is from the streets, all of that by and large meets the requirements. Jim, can you talk a little bit, because, you know, we talked about the planning board, the zoning board, and I just mentioned zones. So from a planning perspective, how are townships zoned? How does that work, and why is that important?
So zoning is underpinned by the municipal master plan. So the municipal land use law, which is the enabling statute, which sets forth all these regulations, establishment of zoning boards, planning boards, permits towns to actually create zoning, is all done under the municipal land use law. And that law requires that the master plan and the zoning ordinance are consistent, or rather that the zoning ordinance is consistent with the master plan. So that's really important. You know, there are towns that have master plans and zoning ordinances that are not consistent, which, you know, creates some problems. But generally speaking, if the town has a good consultant, all good planners know that they have to follow that tenet and make sure that those two items are consistent. The master plan really forms the basis for zoning, and that's, you know, there was some mention before about positive and negative criteria. All variances require a demonstration of both the positive and negative criteria in one form or another, but particularly with use variance applications, the negative criteria are very important because it goes to the master plan, the intent and purpose of the master plan and the zoning ordinance, as well as any impact that that proposal might have on your specific piece of property. So that's where that relationship between the master plan and the zoning ordinance become very important. And that's a point of analysis that you want to look at. And if you don't necessarily want to go wading through the town's master plan, some of them are very voluminous and some are even very outdated. You'll find that most times, if the town has a consulting engineer or a planner, which almost everyone does, their review memos will do a really good job of setting the framework for the application. So it'll talk about the proposal, it'll talk about the specific variance relief that's required. And in all the memos that I prepare for my boards, I talk specifically about the master plan provisions as it relates to the relief that an applicant might be seeking, you know, that particular evening. So the master plan might say something about, you know, the R10 zone in which you live and where the proposal is, and it will most likely say why that zoning district was created and what the underpinnings of it were. If you look at a lot of the larger lot zoning that we have, say in Hopewell Township, East Amwell, most of those were set forth on environmental policies, preserving drinking water and aquifers and preserving agriculture and things like that. So most good planners in a review memo will lay those out. So you don't necessarily have to wade through the 400-page master plan to gather that information. So on top of going to look at the plans, I think if you look at nothing else in that file, look at the consultant's review memo, because it'll inform you very quickly about what the issues are with the application.
All right. So Jim mentioned something about going to review the file. Hopefully everyone knows where the municipal building is and where the file is, but the notice will tell you applications may be inspected during the normal business hours and where. They will also tell you, and this is very important, when the hearing is. So this hearing was at the Cranberry Elementary School because they were expecting a large group of people. Where that is, the date and the time. And so that's important because you want to make sure you show up. And just understand, call the afternoon of the hearing to the municipal official, so the planning board secretary or the zoning board secretary, to make sure that application is going forwards. It is not unheard of, for whatever reason, the application doesn't go forward that night. The experts may not be available. There may be another project that is still continuing, and that's going to take up the entire night. So the applicant is not going to show up and sit there not to go forward. So always call just to make sure. There's nothing more frustrating than showing up for a hearing and then find out you don't have a hearing. But a lot of the information just sort of gets you started to figure out whether this is a project you should be concerned with is in the application. And there was one thing I wanted to point out. Michelle noted earlier, you had this language: the application as proposed does not request any variances, exceptions, or waivers from the applicable provisions of the Cranberry Township zoning code. But they always have this catch-all. During the course of the review or presentation of the application, additional variance, exceptions, or waivers, they may discover it. And so they're putting this catch-all in, saying if during the course of a hearing we find out a variance is necessary, we're leaving it open to get that. In this instance, just as a sort of information, we got this notice here at the Watershed Institute. We went down to the township, we looked at the plans, and I'll show you a sample plan in a little bit, and it was quite evident that this application did need a variance, but it was not shown on any of the plans. So we went to the planning board the night of the planning board, argued that this notice was deficient. And the planning board attorney didn't necessarily agree with us, but the planning board and the applicant did not want to go forward with that application that night because there potentially could have been an issue with that notice, and people knew that this was going to be a project that was going to concern the neighbor. So they did in fact do a renotice and rescheduled the hearing. But here's information from the notice. Take a look at it. Again, it will tell you what they're doing, where they're doing it, and where to go to get more information. Jim mentioned the professional memos, the planning memo, the engineering memo. And so Dennis, being both Jim and Dennis have written these, can you sort of talk about what these documents are? Not in a great detail, but just sort of what they are and where you can get those.
Okay, I can start. Actually, when the application comes in before one of my boards, there's really a two-step process for Jim and I. First step is to determine the completeness. So there's an application. As part of that application, there's generally a checklist. And the applicant has to supply all the things that are on the checklist, or they have to ask for a waiver for those things. Jim and I generally would consult one another, going through the application, making sure we agree that the checklist is complete. If there's any waivers or anything the applicant checked off, oftentimes that happens, he checks it off and he doesn't give it to you, that we try to find, we pick up those things and we write a letter to the board. You're either complete, administratively complete, or you're not administratively complete. And that's our recommendation to the board. It goes before the board. And most of the boards that I've worked for, I make a recommendation, and they take the action at the meeting. The second, and actually in that memo, we would generally describe the nature of the application as well. Have a short executive summary at the beginning of the memo, and then talk about the summary of the checklist. The next thing we do, I would write a technical review memo. I'm sure Jim would do the same. The technical review memo also has the nature of the application, what variances are requested, and maybe what variances were not requested, but things we picked up as we reviewed the application, which is sometimes the case. They don't ask for all the variances, they don't spot them, and that's what we do. It's one of our jobs. So I think it's important. If I was an interested neighbor, I would go in, I'd look at the application carefully. I would look at the checklist. That gives you a pretty good indication of what they have in mind, and then I will start looking through the plans. And generally on the plans, there's a little box, a little like Excel spreadsheet type box on the plans it's called the zoning data sheet. And right there, they kind of summarize, or they should summarize, what variances they need, what all the requirements are, and what variances they need, if they need any. So that's a kind of real quick little look at what's going on with the application.
That's really good, Dennis. I mean, you guys do that, and every planning board and zoning board member rely on those to even to begin to look at the application, is to finally get the professionals' reports. But the public doesn't always have access to those reports as early as it would be helpful in the process.
Yeah,
Sometimes they may not see them. You can see them when you get to usually they'll have the stacks of them, when you go to a planning or zoning board meeting, but there may not be one at the office. So again, that's where you really kind of have to sort of muddle through the best you can. If you get an expert report, it really helps the public.
One of the things I just want to clarify too is a very important issue as to the jurisdiction of the board. So the Zoning Board of Adjustment has exclusive jurisdiction over any application that has what is called a D variance. That simply means it comes under the section of the land use law called 70D. And 70D defines any number of variances that are D variance. Those are the strict and difficult variances. A use variance, something that exceeds the density, something that exceeds the intensity. It's an expansion of a non-conforming use. So there are specifically enumerated D variances. Those are the variances to be really concerned about. So when you look at the application, you want to make sure if it's before the zoning board, you have a lot more leverage because of the fact that they're asking for such relief that is really not considered to be desirable under the law. You could have variances before the planning board, but they fall within the dimensional variance, the setbacks, the height. So long as the height doesn't go 10 feet or 10% above the limit. So there's certain things that fit between one board or the other, and that jurisdictional basis is really something should be looked at in the beginning, because it colors what your ability will be to oppose the application.
So in this example that I have, and everyone's seeing the notice, if, for example, that 174 single family homes was not allowed and they were proposing that in a business district, that would be a D variance, a use variance, and they would have to go to the zoning board.
Yes.
So you would take a look at that and say, wait a second, they're going to the planning board. They can't do that.
Exactly. And that would require them to renotice and resubmit to the correct board.
Yeah. And I mentioned earlier, this application actually does need a variance, is what Michelle called the dimensional variances. It actually, Cranberry has a riparian zone, and relief from that riparian zone or stream buffer requires a C variance, or those dimensional variances, which Michelle talked about. So we've got the notice, and we sort of talked a little bit about going down to the town hall, looking through the plans, You know, looking at the memos, and I will say many of the planning board, zoning board secretaries are very helpful. If they have the professional reports that, and they can email them to you, they will. Not all of them are, but most of them are. They're there to help you and educate you. So, you know, picking up the phone sometimes gets you a lot of information. So, Michelle, you have someone who, you know, got this notice, they gave you a call, you sort of touched on it, and Mary Lou, you sort of touched on this as well. So what are the couple things that a person can and should do as soon as you get this notice?
Well, they should go down to town hall and take a look at the materials that are on file. And as Jim pointed out, and then Dennis pointed as well, you know, the reports of the professionals are very important to review because you get a sense of where they are in terms of the consistency with the zone plan and the master plan, and would give you a hint as to whether or not this looks like a very ambitious variance or something that's worth undertaking. It's very difficult when you fight a permitted use before the planning board. You have a lesser range of issues that you can address, but that doesn't mean that you don't have valid issues. And that ordinarily, assuming that you're not talking about a zoning variance, there's no, you know, no setback variance or anything like that, ordinances have what are called design and performance standards. They are for subdivisions and site plans, and they regulate everything from the streets to the drainage, to the landscaping, to the lighting. And many of these applications have, I would say, deviations from the design standards. They're called either waivers or exceptions. And some of these waivers or exceptions can be problematic for a neighborhood, particularly a neighborhood that may already have existing drainage problems. So, you know, Mary Lou said, you know, if you have something that, you know, really looks like it's going to affect your neighborhood, hire an attorney. I sometimes think that if you're dealing with a permitted use and you have a planning board application, recognizing that unless you have a very well-to-do neighborhood, deep pockets to fund opposition, you have limited resources on behalf of the general public to fight an application. Sometimes the best thing to do is to make sure you have somebody take a good look at the drainage plan, especially if you know you have those kinds of problems in the neighborhood. I have defeated applications on drainage alone because they don't meet what are relatively stringent requirements of state law that have been incorporated into local land use applications. So the stormwater management regulations are very fruitful area, and if you think you're going to have some drainage issues and you see that they have waivers that they are requesting from drainage standards, you might be best, if you have limited resources, to get yourself a good engineer and have them review the drainage and other design standards.
Yeah, all very good points, and I'm going to bring up a plan in a few minutes. Just a couple misconceptions I've heard over the years, and I was wondering if people can address it. Neighbors are concerned about this project, and, you know, absent the current situation where we all are in, all at our homes, many people, you know, work nights or are commuting at night from, you know, a long way, and they really can't get to a zoning board meeting or planning board meeting at 7 o'clock at night, 8 o'clock at night. You know, kids have sports, you know, a whole number of issues, but they're very concerned about it. Can they send their neighbor to represent them and fight this project?
No.
So they can and they can't. So Michelle's right. Nobody can represent you but your lawyer, but you can send a whole bunch of neighbors who would be also affected, right? If you can't go.
Absolutely. Now you to speak for themselves.
Yes, who will speak for themselves. And they should be prepared to explain in layman's terms. They're not required to act as attorneys. Sorry, my dogs are barking.
Yeah, okay. So if you have friends who are concerned as well, they can go. I've seen this one a lot, and, you know, Michelle, if you could comment on this one. I really hate this project. I don't think this works. I wrote a letter to my planning board. I've done my job.
All right, so a zoning and a planning board, when they're acting on applications for development, act in what is called a quasi-judicial capacity. That means that it's almost like a court where you have to have certain fundamental due process rights and rules of evidence. The rules of evidence are not as strict in these proceedings. They're not the formal rules, but nevertheless, you can't have hearsay statements. That is a statement that's outside of the proceedings, that's put into the record because the other side can't cross-examine. Now, there's one famous case where a petition was submitted to a board. The board, in reliance on the petition, denied the application, and the court said, no, that's not fair game, because the applicant did not have an opportunity to cross-examine those who signed it. You know, what did they think was being proposed? Did they just like not want to see any development? What is it? So there's a right of cross-examination. So the most boards, as a result of that particular case, are not accepting petitions or letters at all of any type. There are some boards who try to be a little more politic about it and say, well, we will accept it, but the weight of that evidence will not be strong. But at the end of the day, do not rely on a petition in these proceedings. You need to rely on facts. You need to learn how, you know, unfortunately, you have a very significant economic imbalance. Neighbors, generally speaking, do not have the economic interest in the property that the developer has. Common sense. And a lot of people don't want to put a lot of money out. So there sometimes, you know, depending on the nature of the application and what it is that you're trying to achieve, you will find, and this works particularly well with some of the larger developers, if you get an intelligent group of people that put together a position and go to that developer and say, you know, look, I want to see this buffer increased. I want to see more plantings. I want to see a better stormwater system, more natural alternatives in terms of how it's designed. You'd be surprised. You may get some very meaningful concessions in that approach. Some of them will just say, no, we don't want to talk about it. And then you know you have to go to the board. But, it, you know, especially if the use is permitted and the variances aren't really aggressive. They're not, you know, you're not asking for a building that's twice the height or something like that. I think that, you know, you can gain a lot of leverage just by trying to see if you can't get concessions. Any smart developer does not want to confront objectors. They don't like it. So, you know, you can get some, you know, some benefit from that.
And I would add, if you can't, because there are some who are not so smart, showing up at the board meeting and requesting it in front of the board will often immediately back you up and say, that's a very reasonable thing. We're going to add that into our requirements.
I agree.
You have two shots.
You know, we jumped a little bit ahead, and that's my fault, but here's a question. Can anyone go to the planning board and zoning board and testify or ask questions? Do you have to be a lawyer or an engineer or a hydrologist or a planner? Can anyone do it?
Everyone can do it, and everyone should. If your property is going to be affected, or even your community, and you want to say something as a board member, I want to hear it. And literally, we've had school kids come and testify about what they think will be the impact of some development that they think would cause water flooding. You don't have to be 21.
Right.
Just come, be polite, be respectful. If you're not sure how to do it, ask the chair. Just say, is it okay if I talk about this issue now? I mean, literally, he's like the guy running the show. He doesn't expect you to know all the rules. So just say, would it be okay for me now to show you the pictures of the flooding, or when would I do that? And he will or she will guide you through it. So come.
And if there's a, you know, I live on the border of my town and another town, and an application is in the other town. So I live in Hopewell, there's an application in Pennington. And I have concerns about that, but I don't live in Pennington. Can I show up to the Pennington Planning Board?
You're a member of the public.
Okay.
Definition of an interested party under the land use law is extremely broad. Anyone whose right to use, acquire, or enjoy property is or may be affected. Very, very broad, regardless of whether you live in the town. It's actually, statutorily there. So they, and the other thing I think, and I think that Mary Lou really had this as a thematic approach in her statements. You go to the board, don't blame the board for the fact that this applicant has filed an application that you don't like. Go to the board with the approach that you want to be an ally. You're a citizen of the town, you have legitimate issues. Just try to create a bond, so to speak, that you can then be able to relate your positions and be able to get the board not to look at you unfavorably as if you're some kind of opponent. You're not opposing the board. Now, with that having been said, there are many boards who are extremely oriented toward the development end of things and not toward their own ordinances. Their ordinances may be weak. They are in what is often called the race for ratables. So they'd like to have what looks like such a, have you ever seen all the renderings and compared them to what it looks like afterwards? They get sold by renderings. So it's not uncommon. And you're going to know fairly soon because you're going to, there are some board members who are very, very rude. They think that you are intruding on their purview. They have the right to say yes, no, or indifferent, and they don't need you to tell them. And there are other boards who just welcome the ability of the public to present information. So you want to be able to do that. It is not easy to do necessarily because the first thing that happens is the applicant presents the case. And you're listening and people get aggravated and they say, oh, they're saying there's no traffic on that road, but it's backed up all the time. Or they're saying that there's no flooding and the road is always filled with water. So what do I do? And that's where cross-examination comes in. Everyone, regardless of whether they have an attorney, have the right to cross-examine. If they have an attorney, cross-examination must be conducted through the attorney, not through the person. But that's the trickiest part of what you do. So that's a whole class in itself, how to frame the question. Just remember, you have to ask a question to the witness on the testimony that the witness presented. So I always say to them, take the statement. Did you say that there's no water in this street?
Yeah, Michelle, I want to get into the mechanics of the hearing in a little bit.
Okay.
But two things. So, Michelle, I've seen this happen in a lot of planning board and zoning board meetings. You go up to testify. They ask who you are, where you live. Are you a resident of the town?
Mm-hmm.
That's not important, is it?
The resident of the town is not dispositive. They could ask the question, but it doesn't mean that they can't disqualify you from participating if you're not a resident. Okay.
And then, Michelle, you mentioned, you don't want to be angry at the planning board or the zoning board. You not want to be antagonistic most of the time. Mary Lou, you serve on Hopewell Borough's Planning Board. You've been on Hopewell Township's Planning and Zoning Board. Who are the Planning Board and Zoning Board members?
So there are two different kinds of boards. So the Planning Board is composed of 4 different types of people, one of whom is the mayor or his or her designee, a person he can say, I'm not going to be on the board, I'm going to appoint somebody else to fulfill that seat. One is another township administrator or employee. That's class 2. Class 3 is another member of the governing body. I hope I have my classes right. And then class 4 are other members of the general public, some of whom may be Historic Preservation Commission members. Oftentimes it's a zoning board member. So there's one member that's common to both boards. That's actually really useful. in sharing information about how applications have been processing through the years. So you've got those are the 4 different classes. And then on the zoning board, it's all just members of the public, nobody with a job in the township, nobody with any other responsibilities, just people who listen to hear the applications and follow the procedures and do the vote.
And are there any education, I mean, or do you have to be an architect or an engineer or a planner to be on the boards?
Neither one, except for if you want to be on the Historic Preservation Commission, which could get you onto the planning board. But other than that, no. And there is mandatory training, though, for all of those board members, so that which is provided by the state, and everyone has to get it. I would say it's not exactly, university level, but it's enough for everybody to get a sense of what's required, how to process an application, how to listen. And a lot of people who do this kind of work take it seriously enough that they go for further training and extra training, and that's obviously beneficial to the boards.
But the planning board members and zoning board members, by and large, are volunteers who have day jobs.
Who have day jobs.
Yeah.
Yes, that's correct. And the planning board members, remember, have also been the ones who created or were involved in creating the master plan, which is where all of the zoning then flows from. So they have a real understanding of how we got where we are, hopefully, and of how the ordinance came to be.
And Dennis and Jim, both of you have represented boards in various capacities. Can you explain sort of what your roles in advising the board are, how you were there to be in that process? Jim, why don't you go first?
Yeah, so it's first and foremost, particularly for development applications, to review those against the ordinances and the master plan and give the board a report. But really, the public hearing process is very interactive, particularly with professionals. I know a lot of the boards that I work for, and the point that, a lot of these are lay people from the community that don't have professional engineering experience, architectural experience. I mean, sometimes you get planners and architects and engineers on boards, but it's not common. So a lot of times it's an interactive process for us. Board members might have questions, technical questions about the ordinance, ordinance requirements, things like that. So it's, a lot of times it's interactive, and we'll field questions. We might answer questions from the public too. They might have questions about ordinance requirements that we'll answer as well.
Dennis.
Well, I agree with everything Jim just said. What I try to do in the memos is point out the technical issues and bring up issues, and I'm sure Jim does as well, that maybe might set the board to thinking about some of the aspects of the application too. So at the public meeting, sometimes the board will ask the engineer or one of their professionals a question or an interpretation, or where's that in the ordinance, and could you read me that section so they can understand it a little bit better.
Yeah, and Mike,
add that there's really heavy reliance by the board on their experts, because like Jim and Dennis just said, they're not experts. So Dennis is going to have to explain how that engineering process works for the average person on the board and for the public. And if we don't have that, we can't make good decisions.
And Jim and I are usually and the attorney are the only people in the room that have the ordinance in front of us. Yeah. So, if there's a question, we have to know how to find the answer in the ordinance pretty quickly.
And Mike, I view my job as an expert for the board, not to tell them how to vote or tell them what to do. It's more just to lay out all the relevant information for them to consider and point out, all the relief that's required, all the considerations. I might say something like, the applicant's seeking a variance for the buffer width. They're providing 20 feet. I don't, that's not enough. I might say that in some instances, but I won't. Ultimately, the board are the people that make the decisions. We just kind of give them the information, and I've had instances where board members look at me and say, well, how would you vote on this? But I kind of shy away from that, because I don't think that's our role as professionals advising the board. It's more to just give them the tools that they need to make good decisions.
All right. I'm just going to see if there's questions. One thing, someone mentioned environmental commissions. A lot of environmental commissions will review applications, and that may be an early warning that an application is coming before a planning board and zoning board, because they tend to be before those meetings, sometimes a day or two before the meeting, sometimes a month or two before the meeting. And the Environmental Commission will issue a memo, which is also available if you ask for it. And they will also, provide a lot of guidance on how to look at and think about projects. So I want to switch a little gear.
Sometimes an environmental commission member will be a member of the board as well on the planning board during the structure of how you can have different people on it. And that's helpful. Many boards, most of the boards that I have been on have taken environmental commission input very seriously. I will say that there are other boards that don't. And
the planning board, the environmental commission's recommendations or concerns, those are advisory. They're not
binding.
Not binding. All right. So I'm now showing a plan for a project that is several years old, one I was involved with. This is a project that was before a zoning board because they needed a use variance. There was a non-conforming use. And this application had lots of different things in it, and I may use a little bit of license in it. So Jim, as I mentioned, this was a use variance. There was an existing non-conforming use that they wanted to take that lot, subdivide it, and create all of these houses. Just very briefly, can you explain what a use variance is, non-conforming, and why does this matter?
Sure. So a non-conforming use, an existing non-conforming use, is one that predated the zoning ordinance, or maybe at one time was a permitted use and then the zoning changed and then it became a non-permitted use. But it's an important distinction, because a legal existing non-conforming use under the municipal land use law has the right to continue. But the important part of that is it says, I think the phrase is on the lot so occupied. And that's why this particular instance gave rise to the need for a use variance, because when you subdivide the property that existing non-conforming use is on and you make that property smaller, it is no longer on the lot as occupied. And the New Jersey courts determined that requires a use variance for expansion of a non-conforming use, which is what's called a D2 variance. So Michelle mentioned that section in the municipal land use law, 70D. There are 6 variances that are there. The first and probably the most difficult to obtain is a D1 variance, which is for a use or principal structure that is not permitted in the zone. So let's say someone in your neighborhood decides they want to try to build a gas station on the corner and it's a residential zone. That would be an example of a D1 variance for a principal use that's not permitted. The D2 variance is an existing non-conforming use that someone wants to expand. You might have a funeral home that's in a residential zone and they want to put an addition on it, and it's not permitted. That would require, but say the funeral home's been there, for 100 years. That's an example of a legal existing non-conforming use that they have the right to apply for and expand, and that's a D2 variance. The other variance is D3, is a conditional use variance. So there are uses that are permitted in zoning when certain conditions can be met. So it might be a certain lot size, it might have to have certain setbacks, other factors that the governing body has determined need to be met in order for that use to be permitted. You can deviate from those standards, but it requires a use variance. And then the other 3 are more intensity variances. So density is D4. D5 is floor area ratio, which is the total floor area of say, a non-residential use or even a residential use these days that exceeds what's permitted. And then the last one, which Michelle had mentioned before, was a height variance. And when you exceed the height by more than 10 feet or 10%, that becomes a use variance. It's what we call a D6. So I think there are also varying degrees of legal proof that are required. I, as a planner, I do work for private clients as well as municipalities, and I'm often hired to argue in favor of these variances. And I would say the D1 variance is probably the most difficult to achieve because in addition to what the municipal land use law says you have to prove, the New Jersey courts have come up with additional standards through case law that we have to address as well. So the D1 variance requires a very high level of proof, and is one that if someone's proposing one next door to you or in your neighborhood or your community, that's probably the one you want to be most concerned with at any point. The others require kind of what I'll say is a lesser degree of legal proof. Still the same positive and negative criteria, but as with all uses in the state, the courts have kind of gotten a hold of all these and changed, modified the criteria somewhat. So those other variances that I mentioned are probably a lesser degree of proof that's required. And the ones that I like to see, because then my job is not so hard.
So Jim, you mentioned density. In layman's terms, what does density mean from a use variance?
So density is usually expressed as a requirement maximum number of units per acre. So, in this zone, I think in the R10 zone, you can have lots as small as 5,000 square feet. So that would be expressed, it's somewhere around 9 units an acre. So that's just an expression of the number of units per acre of land. And obviously, here in Hopewell Township, we have some zones that are 14 acres per 1 unit. Some are 6 per 1 unit. And then, we have others that are much smaller, like 20,000 square feet. But density is a term and that's how we describe it.
So if this application had wanted 10 units per acre and only 9 was allowed, that would be a variance?
It wouldn't. It would be in front of the zoning board. As Michelle had pointed out, the zoning board is the only board that has jurisdiction over D variances.
And so, Michelle, you mentioned and Jim mentioned these positive and negative criteria. Can you sort of go through what those are and why is that important?
Well, they're very flexible criteria in many respects, and the criteria vary greatly, as Jim started to point out, based if you have anything that falls within the D variance category. The courts have carved out different proofs that are necessary for each different type of D variance. So it gets to be a little complicated, and I think we would kind of lose everybody on that topic because they are difficult, and even a lot of land use lawyers have to scratch their heads when they're dealing with them. But generally speaking, they have all variances, regardless of whether they're C's or D's, have what we call positive criteria, and then what we call negative criteria. So the positive criteria on anything that is a D variance, putting aside these little wrinkles and permutations for the subcategories, basically are what is a special reason. And that is, it's been addressed by case law for a really long time. And I think the easiest way to understand special reasons and the easiest way to fight a D variance is because of what is called, and this is a D-use variance, that is, the use is not permitted in the zone, as Jim said, the toughest of the Ds to get. You have to prove that it meets one of the purposes of zoning, which basically you could come up with 1,000,001 purposes of zoning that could be met, because one of the purposes of zoning is to encourage senior citizen housing, to encourage the appropriate use of land. It's a pretty loose test. So the courts, for a D variance that is not what is called an inherently beneficial use, and I'll go over that in a bit, said that if you want a D variance that's not inherently beneficial is like a church or a school or something that has a general public benefit, you must prove that the use is particularly suited for the property. That is a very tough test. Very, very tough test. So if you fight a D-use variance, you have a lot of leeway in terms of meeting that test. If you have an inherently beneficial use, as I said, something that is what charitable institution, seeing eye dog facility, hospitals, those are considered to be inherently beneficial. They don't need to meet the particular suitability test. And the height and the height and the density variances really depend greatly on what's in the neighborhood. Courts have kind of whittled it down, and I don't really, and most of my colleagues that do land use law, particularly from the municipal perspective, have found that some of these decisions have so liberalized the test that you might as well not have a density or a height variance. But putting that to the side, all variances, whether they are D variances or C variances, must meet negative criteria. So Jim said, well, you want to look at one of the negative criteria is substantial detriment to the public good. The applicant has the burden of proof on the positive and the negative and must prove that there's no substantial detriment to the public good. What does that mean? Well, basically, if you're introducing a new use or a new type of incongruent development, you might have difficulty proving that D variance. I mean, that negative criteria. The other negative criteria is no substantial detriment to the public good. What does that mean? Well, negative drainage falls within that. Negative impacts on the environment can fall within that. Negative impacts on property values. It's very, very broad. The system is shot full of discretion. It is set up in a way that the discretion in municipal agencies is very, very broad. Somebody a long time ago taught me something, and it always stuck with me. I would say that in about 90% of cases, if the board says yes, the court will sustain the board. If the board says no, the court will sustain the board. It depends on the board's decision, which at the end of the day is vested with what is called a presumption of validity. It means it's presumed to be right. If there's any evidence in the record, they're going to be presumed to be right. And you could present very thorough evidence in opposition, and they don't like your witnesses and they reject your witnesses. You're going to have a hard time on appeal.
So, Mary Lou and Michelle, it's up to the applicant to prove that they should get a variance. It's not they get a variance unless someone can prove they shouldn't.
So I think you're saying it's really up to the board to decide if they're going to grant the variance, and it's pretty clearly stated, I mean, pretty clearly understood that it is the exception to receive a variance. Like, I think a court would agree that generally variances, because of the way land use is supposed to work, is not working on a case-by-case basis. And so it would be the exception rather than the rule for variances to be granted in general.
And they say, we want to plan by planning, not by variance.
That's supposed to be the way.
Yep.
But
and so I think what Michelle is saying too, is that especially a denial of a variance is almost, I mean, I don't want to say 100%, but it's very, very likely a court will uphold a denial of a variance.
Except if it's for a vacant, undersized lot and there's no land on either side and nobody wants to buy it. That's the worst area of all to be opposing to.
Yeah, you know what? We had that situation. A lot was undersized. It was subdivided before the zoning changed, but they never built on it. And one of the sticking points, did they ever actually offer it to the neighbors? Did they try to buy a sliver of land so their lot would then be compliant?
Mm-hmm.
That was an issue. There was some headaches with that. As as I said, here's a plan. Jim, so we talked about the negative and positive criteria. This was a housing development surrounded by some non-conforming uses, but also other housing developments. And so just from a planning perspective, is this a good use variance, a bad use variance?
Well, this one was interesting because the non-residential use that was there had existed for some time. You can see on the plan here, that's building A. The Villa Ristorante was another exist. So you have a couple of non-residential uses in the area, but it's in an R10 zone, and that's not uncommon for this community. There's a lot of mixing of uses in residential zones, and it creates a lot of issues like this where you have mixed uses, and these things do exist next to each other. But really, the issue for a case like this is, separation of these uses. I mean, the tendency for zoning in most suburban municipalities and rural municipalities, anyways, to segregate uses. There's kind of a trend now, or there has been for quite some time, to have these mixed-use developments like Robbinsville Town Center, like Plainsboro Town Center, trying to recreate downtowns like Pennington and Hopewell and Cranberry and places like that. But this one, it's interesting because aside from the use variance for the expansion of the non-conforming use, which actually wasn't an expansion, it was more just a reduction of the area that it sat on, this application was largely conforming. As to the lot sizes of these homes was conforming. I can see that this is a pretty narrow corridor that they were trying to put all these homes in. So these are pretty tightly packed, but this is a small lot zone in this community. And it's those issues where a developer comes in. I think the focus in this one in particular was probably more the juxtaposition of the non-residential use versus the new houses, but the conforming aspects of it, it's difficult to show up and object to conforming applications. You're likely spinning your wheels because legally, if an application conforms to all the standards in the ordinance and requires no variances, really a board doesn't have any choice but to approve it. There's a lot of cases where fully conforming applications are in front of boards and a lot of people show up and don't like it, and a board might deny it, but that's never a case you're going to win in front of a judge if there's no variances required.
But when Mike and the Save Hamilton Open Space people appeared at this hearing, they were not going to win on what was legally allowed. They were going to lose on that because it was legally allowed. But they did have a positive impact because by being there and showing the pictures of how they would be impacted if there wasn't adequate screening and raising the question about testing for lead, they got the board to put in the resolution, this will be done under the auspices of the township engineer. We're going to check for drainage issues, I think it was, Mike, water, dry wells, all of this other stuff that the zoning board or the board may have never even considered or known about. But by having the public there, they got a better outcome, even though it wasn't required legally.
Yeah, I mean, this application, this was one I worked on when I was in private practice. Ultimately, I think somewhat of a modified project got built. And one of the things, I hope everyone can see sort of a red highlighter.
Yep.
So this is the transition area for the wetlands. I don't know if anyone wants to handle it. A lot of times projects have wetlands and there are impacts to wetlands and there are, impacts to that buffer, that transition area. Can the township, the planning board or zoning board do anything about that?
Not really. If an applicant has gone and gotten permits from the New Jersey Department of Environmental Protection, and they're issued permits for, the first thing is they have to go get what's called a letter of interpretation. And that's an agreement by the DEP that the wetlands delineation that's performed by the applicant is concurred to. And then the other part of that often is a determination on the nature of the buffer. So ordinary wetlands require a 50-foot buffer. If there are endangered species or it's classified as an extraordinary value wetland, resource value wetland, then it requires 150. There are also areas of the rules where an applicant can reduce a buffer in certain areas and then replace it with some in the others, but they can only go down, I think, Dennis, it's half of the required buffer.
I think that's right, Jim. That
Yeah, so it's called transition area averaging, and they can reduce the buffer in some places and replace it and increase it in others. So, but generally speaking, you know, a municipal board can't really argue with a delineation of wetlands if it's, you know, concurred to by the DEP.
Can a municipality regulate wetlands independent of DEP?
I don't believe so.
I don't think so.
It's one of the few areas where DEP says municipalities cannot do stronger, they cannot regulate it. As Jim said, if there is a transition or waiver or buffer averaging, the planning board, no matter how horrible this may be to the planning board or to the zoning board, they really don't have that. Townships can have a stronger stream corridor ordinance or a stormwater ordinance, but this is one of the few areas where what DEP says rules.
And Mike, you know, they just expanded, you know, they just added 750 new miles of stream to the, you know, the C1 designation in you know, different parts of the state. So I see the trend is going, you know, towards more stringent environmental regulations at the state level, you know, not the opposite.
And
I'll get a new administration, and that's the, you know, of course, that put all change. I want to just say one thing that I think is important. Maybe not, part of it is a minority view, and the other part of it is not. And that is, first of all, an application, the familiar term that developers like to use is as of right. We meet all the requirements of the ordinance, we're entitled to approval, and you cannot say no. That particular as of right holds for not just the variances and the zoning criteria, but for the design and performance standards. So if there is a requirement applicable for stormwater management, or there's a requirement for buffering, and it's in the design and performance standards, the board can deny an application and be sustained if the applicant refuses to meet those standards. So it's a little less likely that you'll see that, but it can be the basis for denial. And I've actually had defensible denials that were in situations where the zoning was met, but the design standards were not. The other little wrinkle has to do with it is a section of the land use law, section 22, which says that the municipal agency, and that's the planning or the zoning board, shall in appropriate instances condition its approval on the approval of the other governmental authority. So you have an application comes before you, they have to delineate the wetlands, and they have to get wetlands permits potentially. There is one decision, and it's actually a published decision, which addresses this particular issue. And if the applicant comes before the local board seeking an approval, and evidence is presented, in this instance, it was the town engineer that identified to the planning board that they needed a dam permit. And you can need a dam permit for a detention basin, okay? And that's really what it was. And they didn't have the approval of the state. And the board denied it and said, look, you know, don't come to us with something that we don't know you're going to have a state approval on. That it was not an appropriate instance for them to condition the approval on state permits. They denied the application, and the court sustained the denial because they said, God bless, they said that the changes that would be necessary in order to accomplish to get these state approvals would so fundamentally affect the entire plan that the board didn't have to approve it until they knew what the whole dynamic of it was going to be. it's a kind of a narrow exception on that one, but it is something that can be fruitful. That's why I say sometimes when you have a variance before a planning board, if you have an application before a planning board, get a good engineer and have them review it. Sometimes the town engineers, they have, they don't always see everything. Let's be honest. I mean, sometimes politics prevails. I'm sure that wouldn't apply to Dennis or Jim, but
So,
Thank you. And that's true.
And Mike, this might be an opportunity just to jump in real quick and talk about, because Michelle's brought up, we've talked about it a couple of times, design waivers and exceptions. It's relief that an applicant must seek. The standard is much lower or less than a variance. And really the municipal land use law, I think it's section 51, outlines the provision. So if you have a fully conforming application that comes through the door, as I said, it's hard to fight, but if there are design waivers and exceptions that are required, the applicant still needs to demonstrate to the board that imposition of that standard will cause undue hardship or is impracticable. And the literal enforcement makes a difficulty for the developer. And the courts have said that the developer just has to show that the waiver is reasonable under the facts. And the word reasonable comes from the municipal land use law. That's an area, unfortunately, a lot of times design waivers and exceptions kind of get glossed over in testimony by professionals and applicants. People kind of just think it's a fait accompli. Well, we need this relief and, we're going to get it. We can't do it. So a lot of times that's another area to focus on. And, you can press a developer in questioning and their witnesses to say, well, okay, so tell me what the hardship is. Why can you not comply with this requirement, or why is it impractical? Because that's important. A lot of times it's not at the forefront of an application, but it's an important area to focus on if you don't have anything else.
yeah, Jim, you brought this up and I was going to ask you and Dennis. So this is straining my memory, but I'm sort of highlighting a dashed line on this lot.
Mm-hmm.
That is sort of the housing envelope, and the
Right.
Hamilton Township ordinance required a usable backyard. So in this instance, a good chunk of this lot and almost all of the backyard was encumbered by the wetlands transition area in this instance. So, there was an argument that that's not a usable backyard because that's wetlands and you can't really build in it. You can't really do anything about it. So would that be one of those sort of design waivers that might go, be asked of a board to agree to?
Yeah, sure. I will say that's quite a subjective standard. One that I would try to avoid putting it in ordinance, because it's, I always try to think, well, how is this going to be judged in front of the board and by an applicant? And it's best to have clear standards that you can gauge, I might have said, hey, you have to have a backyard that, extends at least 30 feet from the rear of the dwelling and is not encumbered by wetland transition areas, or something along those lines. Because those subjective things are it's really hard to win that argument.
Yeah. There was a certain width required, and so one of the arguments myself and others made is, if it's all encumbered and you are not able to do anything unless you have to go to DEP to get a permit, how's that a usable backyard? How's that a backyard that's usable?
Michael, there are other design standards, waivers too, for other things that I think are equally important.
Mhm.
Number of parking spaces is usually in there.
Yep.
The roadway design, what's the maximum slope on the roadway? Lighting, and so something like parking would be, that could be an issue if you get a waiver for the parking, the generation of the parking spaces, and it's, you come to find out you don't have enough parking spaces after the project is built. Sort of the worst is out of the barn at that point, and that's makes for a bad project. So, and that's one of those things that, that is one of the design waivers that usually boards do talk a little bit about, more so than the roadway design or possibly the lighting and some of the other things. But there are important design waivers, I think.
Yeah.
Yeah, so Dennis, Michelle talked a little bit about this, drainage. One of the big issues here at the Watershed Institute is stormwater management. And in this plan, if I can figure out how to zoom it back down a bit, there's a big basin in the bottom of this, right in here. Each house had what's called a dry well, but the lots originally, this lot originally sloped this way. So if I was a neighbor to here and I am already experiencing flooding, are there things you could suggest that people look for, whether it's in the plans or elsewhere, that would be helpful for them to bring to a planning board or zoning board hearing?
Well, I think the board would like to hear if you have some local information about, this area has always been problematic since I've lived here for 30 years. And it's not just a once in a fluke of flood. I think the board would want to know about that. The engineer, the municipal engineer would probably want to know about that too. But so that if the design is done correctly, the DEP has standards for the stormwater, as you know, right? They're quite strict and you don't have a whole lot of leeway on some of that. And one of the things that you do as far as the design goes, there's you break the subdivision up into sub-drainage areas. So, and the idea is that when you have the drainage area as it sits right here with only the building on it, but it's not developed with the homes. You can tell where the drainage is going to go by what the topography says. It's on the map. So you can figure out how much drainage is coming from one sub area going to somewhere else. In this instance, between those homes that you were talking about. After it's graded, like this is, you develop another map to show where all those sub areas are going and how much is coming off of each one of those sub areas. And it should not increase. And in fact, the DEP has it, so you have to decrease the runoff. So it should be a good thing. Now, so that's sort of like the mass, the road, because obviously the road's going to generate a lot of runoff that was not there before. The idea of the dry wells is, the trend is that for new homes, each individual home would have a dry well where all the impervious from the roof, the clean water, would go down into it, basically a hole in the ground by the house that has stone in it, and the earth has permeability. It doesn't help you if it's all clay and it's not going to go anywhere. But so they would have dry wells for each one of those homes, and that would help reduce the amount of runoff. And there is a lot, I'll have to say, I was not the drainage expert in our office, but there is you pick a lot of numbers off of curves as you do these things. And there's a certain amount of interpretation on portions of the design. And that's why I think why the DEP has built-in reduction factors as you do these things for different size storms, 100-year storm, 50-year storm, or 10-year storm.
All right. But so it would be useful, and anyone jump in, if residents showed pictures of flooding, dates, times, how much it rained. That would be useful information that you didn't have to necessarily be an engineer to do, but you as a resident who's lived there for 10, 15, 20, 30 years could present, and that would have some usefulness.
Absolutely. And remember that neighbor may not have had a chance to go take a picture because they had 9 days notice to show up and do this. So there might not be a photo, but they're going to testify. They're going to raise their hands. They're going to swear under oath that it happens, however many weeks a year. And that's going to be relevant to me as a board member to hear that as well.
Yeah. So, Mary Lou, you talked about this. As a board member, the public comes up, they want to give a comment, they get sworn in. Are there any restrictions on their comment? How does that process generally work?
So as Michelle said in the beginning, before they do that, they're going to be doing, the way the structure of the hearing goes is first there's testimony. So they're going to be asking questions of the people who already testified. They're going to be cross-examining the expert, perhaps, of the applicant. But then when all that's over, the chair will usually say, I'm going to open the floor to comments now. So you can get up and make your comment about the application. Honestly, the comments are helpful, but testimony is more helpful because I can really use that as part of my basis for making a decision. But I mean, comments are useful, and a lot of times people, there's a pretty fine line between comments and testimony sometimes, so both are helpful.
But my experience, boards limit the length of the comment or testimony. Can they do that?
So Michelle will have to say if they can limit testimony, because I'm not really sure if I'm really legitimately cross-examining a guy as to what he testified for. I should have pretty long leeway as long as it's, I'm not being repetitive to cross-examine him.
So there's the test for cross-examination is that, number one, it has to be relevant to the questions and it's not unduly repetitious, okay? So that and a lot of boards, the practice is to try to combine public comment with public questions because most members of the public find it difficult to formulate questions that are, within the confines of cross-examination. You listen to the engineer and you want to ask questions about what color the building's going to be or something. So the procedure varies significantly from town to town, but there's no authority in the law for an across-the-board time limitation when it comes to your public comments, or for that matter, when it comes to your cross-examination. And it has to do with whether or not it's unduly repetitious. The chair gets to make that call. And I personally, if I'm a board attorney, I don't recommend putting in time limitations when the applicant may have taken 3 hours and you're going to say the next door neighbor that you have 5 minutes.
Yep.
So I don't believe in across the board arbitrary time limits. I think what the statute authorizes is the chair, presiding officer, gets to exclude testimony or questioning that is repetitive or, irrelevant. That's how I go by it.
Yeah, I will say many towns will take the public comment portion and we'll limit it to 3 or 5 minutes for an initial round. They'll give you a little bit of leeway. As Michelle, you said, if people are being repetitive or bringing up issues that have no relevance whatsoever, that leeway sometimes goes away. And then sometimes the boards will allow someone to come back up after everyone has had a chance. Mm-hmm. But what's the best way for someone to figure out how that board operates? How do they like to do combined testimony, cross-examination, comments? How long? What's the best way for people to figure that out?
I wish I could answer that question. Statute.
I thought that was an easy one.
Yeah, no, the statute says that boards are supposed to have rules and regulations. Okay. There are very few boards that have rules and regulations. If you go in and you say to the board, how you secretary of the board, how do these go? Well, it depends on the chair, depends on how busy they are. It varies so much, and a lot of town boards don't have the rules and regulations. So that is really the beginning point. The courts have generally allowed boards to kind of make it up as they're going along, although in one particular appellate division decision, they did chastise the board for changing the procedure repeatedly over the course of one application.
All right.
So I think that we're coming to a point in time where we have this, it's this one particular decision that the appellate division really said, you know, this is not the way to operate, not go changing the rules as you go along. And so when you see a case like that, and then the next one comes along and they're changing the rules, that's very helpful if you ever have the money to file an appeal, because a court says, wait a minute, you know, we gave you, you know, we gave you a slide on this. We said, you know, you can, you know, you should have rules and you should follow them uniformly, and you didn't. And so we're going to reverse, but that hasn't happened yet. Procedural cases vary greatly. They really vary greatly about cross-examination, about procedures. They're not nearly as strict as you might have in a court, and it's just so hard to predict. And that's why I always say, no matter what side of the table you're on, try to be fair. Try to let people get their evidence out, let people ask reasonable questions, try to help. I mean, it's, you know, sometimes somebody has a really good question, but they just can't figure out how to make it into a question. So I always say, well, didn't you testify that there are no cars at this traffic light in the morning? Yes, I did say that. That you take their statement and make it into a question. You said that, didn't you? That it takes a little bit of training, but somehow they should be helped. And most boards just get, a lot of boards get very, very irritated by the members of the public trying to ask questions. So it's not easy. And there are two distinct different rights. One is the right of cross-examination, and the other is the right to comment and testify. So, you know, don't let them get you wound up in the middle of it, but some boards will say, come up and you do it both at the same time. So there's just no hard and fast rule that I can give you, unfortunately.
Yeah, I will say, if it's a board I haven't appeared before, or a board I haven't appeared for before recently, I will either ask the board secretary, how do they like to run things, or I'll ask the board attorney.
Right, and a lot of times they don't have answers.
They don't. They try to help. And then I was cross-examining the applicant's experts. You know, so the applicant will have an engineer, they will have a planner, they will have an architect, they may have a hydrologist or a stormwater expert. And and this was a significant application, and the board chair goes, "Are you done? Are you wrapping up?"
Yeah, I didn't get started yet.
You know, and that's a very hard thing to deal with as a professional, as a layperson. That's got to be very nerve-wracking.
Right, because you knew to say, you know, I have more questions that I'd like to ask this witness,
Yeah.
and the member of the public just thinks they have to sit down and be quiet. And I think we're here to say you don't have to, as long as you're polite and you follow the rules of procedure and you say, I just have 5 more questions, and then I have a question for the other guy.
Yeah.
We've been at meetings where you'll see literally you're cross-examining an expert, and the township attorney will answer. I mean, sometimes things are so out of whack. Yeah. You're like, what kind of hearing is this? And if you are familiar with procedure, you know that's crazy. But if you're not, you just sit down and think, I don't even know how this works. So right. I think it's great that you guys are doing this talk tonight, Michael, for that.
Yeah, and a lot of times an application is just not one night. It is multiple nights. So sometimes you're in for the long haul. I've been trying to sort of get to some of the questions.
Yeah, I see a bunch of questions here.
Yeah. So here's a good one, because this is really, where was it?
Well, I see one I'll answer real quick while you're looking, which is, what's the best way to get on the planning board? The mayor appoints every member of the planning board except for the class 2 member. And a lot of people will send letters to the township clerk and say, I'm interested when there is a vacancy in being considered, or reach out to the mayor and say, you know, something I'm interested in. If you start showing up at meetings pretty regularly, they'll get to know you. It's interesting. It's certainly good public service. So reach out and try and do it if you're interested in it.
I've seen, Mary Lou, a lot of websites when I'm looking at different planning board and zoning board pages, they actually have a link that says click here to volunteer, and then you can fill out a form, and then it goes to the town and then they put your name in.
Great.
Here it is. Plans are being submitted that originated in affordable housing mandates settlement agreements approved by a judge. How does this impact the process? I think that could be an entire webinar on itself. But if someone wants to tackle that one, because that is a very timely and pressing one.
Michelle's going to do that one. That's all.
My least favorite area of the law. I always say that if it's affordable housing, it comes with a halo on its head.
Exactly.
That's true.
But the case that I mentioned earlier about the Section 22 conditional approval and the dam, that was actually an affordable housing case. And the courts nevertheless said, you've got this, there's no exemption from the rules because you're affordable housing. What does happen is oftentimes they are accompanied by fast track, it's called. They are entitled to expedited consideration and treatment. So, and many times the boards are just, the towns are so worn down by the litigation in which they've been engaged for the affordable housing that it's like, we don't want to hear anything anymore. We went through this through 3 years of litigation, and they figure it to be a done deal. So I think that you should approach it. It's a use. It's the same thing as any other use. And although it may have some preferred status, look at it from the same perspective. Do they meet the criteria? Do they have justification for variances and waivers? Do they have a solid way? Do they have a good stormwater management plan? So just look at it from the same perspective. And, ordinarily what you're seeing is, maybe 20% of the development has affordable housing units. So you're really not getting a lot of affordable housing. And so, a lot of times the boards aren't very favorably inclined. Everybody's just sick of dealing with it. It's terrible area of the law. I just totally got out of it because it's just got to be such a numbers game and has been such a difficult situation for most communities.
And Mike, I'll say this, our office does a lot of affordable housing work, and all three of us are court-appointed special masters. So most of those, if you read through the affordable housing regulations, what was the Council on Affordable Housing's rules, they say for inclusionary developments, which is the approach that most towns have taken to meeting their affordable housing obligations. It says that, boards are supposed to make reasonable concessions to developers and grant what they call reasonable bulk variances. Mm-hmm. So it's a little bit of a different category of use, but most of those have gone through a process where a zoning ordinance was developed. There's been a planning process associated with that to create a housing element and a fair share plan. And towns were scrambling to meet these settlement numbers. Hopewell Township most prominently. It was a significant obligation, and you have to go around and find places for these sites to go. And a lot of people might not have been paying attention when all that was going on. I mean, a lot of it was publicized in Hopewell Township very well, so I feel like a lot of people got involved in it at that point. But unfortunately, it's not on a lot of people's radar. But you're supposed to give a little bit more deference to an affordable housing developer. And the rules don't say they can just walk all over the regulations, though, particularly environmental controls like steep slopes and, buffering and things like that. But towns are supposed to remove what are called cost-generating features. So unfortunately, a lot of times that's significant buffering, significant setbacks, things like that. So a little bit more difficult to fight something, particularly if it's in a court-mandated plan or a court-approved plan, I'll say. But, you can still go, participate, have questions, get answers, and express concerns. I mean, it doesn't mean that's all off the table.
Absolutely.
So, I'm sorry, Michelle, go ahead.
What Jim said is just absolutely correct, but I think there's something that I feel compelled to say, and that is that you should not get involved in local planning just because you got a notice in the mail about an application. Pay attention to the underlying zoning and the underlying master plan process, because that is what is going to shape your future. You're not going to preserve the environmentally sensitive features of your town on an application by application basis. Find out what's going on. When did the planning board last do a master plan or a master plan reexamination? Take a look at, know what your zoning is. Is this appropriate for the area? And try to do a constructive participation in basically what is the underlying zoning and foundation of your municipality.
Yeah, and I think hopefully if there is interest, we'll do another webinar on the master plan, the master planning process and the ordinance process, because one of the reasons I decided we should have this type of webinar is you go to planning board meetings with, by and large, a compliant application, and people show up going, well, there should not be a warehouse here. Well, it's been zoned for a warehouse for 20 years.
Exactly. Yep.
The time to fix it was not when the application came in.
It might have been Michelle Donato who said this to me and a bunch of other planning board members during our master plan process, but she said, you will get the development you deserve. And so if you want to get development that you want to deserve, you need to do a master plan, and you need to be involved from the beginning on the ground, watching how that plays out from master plan to zoning ordinances.
Yeah. All right. Another question. And Michelle, I'm going to direct this one to you, but is it beneficial to periodically submit Oprah requests to try and gain access to applications before they appear on an agenda? And if so, how early does an application arrive to the township before it is brought before the board? So actually the first part, Michelle, if you can handle, and then Jim and Dennis, if you can handle the second part.
Oprah requests, if you don't know if there's an application, the Oprah is not for research. They don't have to research anything. So you have to be able to identify, is there anything happening on lot 1, block 2? It's not, you can't just say, Joe, are there any applications? So, it's really a good idea to at least, look maybe at the agendas of the boards, try to take a look at those in advance, try to see if you see anything in any of the other township materials, but I think it's really hard to do it in an Oprah survey.
It is, and Michelle, what you're saying is right. Look at the Environmental Commission, because they do get advance notice a lot of times. Look at their agenda. And if your town has an application review committee, that is an early warning sign of something big that might be coming. But it's really kind of, in New Jersey, not fair to the general public how this process works.
No, it isn't.
Like we said, you've got a 10-day notice. I know in some other states, including Florida of all places, if there's going to be a development on a property, there has to be a billboard constructed on that property with a sign saying, planned development here for townhouses, just massive warning to people in advance. We can't, Hopewell Township or Hopewell Borough can't make the rule that we require that to alert people. It's statutory. The state makes the rules. But I would love if the state made a few changes to the rules to make this just a little bit more citizen friendly and a little less applicant friendly.
Yeah, I would love at the very least the mailed notice to the 200 feet neighbors is actually received 10 days beforehand versus just mailed.
Right, or maybe 2 weeks beforehand would be good.
Yeah.
Any improvement would be good. It's very hard. I see it's Melanie's question about how to find out beforehand.
Yeah.
You almost can't.
Yeah. And so Jim and Dennis, sort of by the time it gets on an agenda and a notice, how far along in that process has it been, and when does the application really come into the township?
I'll say it really varies. So a lot of towns that I work for and at my urging, they do completeness as a whole separate process from public hearing. So most will not have a public hearing the same night that they deem an application complete. I think it's 45 days, Dennis, we have for a completeness determination.
Yes.
So from the day that someone submits what we'll call a complete application, meaning they've submitted the checklist and they've checked everything off and they've submitted everything that they're supposed to, or they're asking for appropriate waivers, the town has 45 days. And as Dennis said, a lot of times there's a completeness review that happens first. That goes to the board. So it's usually helpful to just check agendas. take 3-4 minutes, go to the township website, pull up the agenda, because it'll actually say, you know, block 2, lot 1, completeness determination. And then they might list public hearings in a separate section. So you can catch an application at a completeness determination, and then you know it's there. And then you're going to have in a lot of cases, you'll have a whole nother month before it's actually going to be in front of the board for a public hearing, which would give you time to do that. Most minor applications, you know, minor subdivisions, minor site plans, most boards will, you know, have a completeness determination and a public hearing the same night if it's, you know, not complicated. But and it varies. I mean, some towns like Branchburg Township, where we work, all the completeness determinations come from the administrative officer. The board does not act unless there are waivers that have to be granted. That administrative officer actually makes a completeness determination, and then it's scheduled for a public hearing and waivers with the board. So it varies widely, really.
Yeah. I know, Dennis, if you have anything to add to that?
No, other than, you know, most towns that, you know, I've worked with, we have submission windows for, published submission windows for the application. So the window might be a 10-day open window, a month before the application is, before you want to get onto the meeting. So supposedly, I mean, you may not know, the application would be in the office, in the planning board secretary's office, but as a resident, somebody nearby, you may not know that until you get the public notice.
Yeah.
The public notice, but it's usually there way ahead of time.
Yeah. I mean, one of the ways, if you start seeing things going on the property, as one person mentioned in the question and answer, you sometimes applicants go to DEP for that letter of interpretation. So if you see flagging, you know, literally little flags on the property, there may be something going, and you can go to what's called the DEP bulletin and try to find it. So that might be a way to get maybe a little bit of an early warning.
They apply for an LOI or something like that, and you're within 200 feet, you're going to get noticed on that.
Yeah. And a lot of times that's before an application is submitted to the township, but not always.
Right.
A lot of, I have seen several of them where we're in the process of getting an LOI, or we're applied for an LOI.
Yeah.
And it's not unusual for the applicant to go get DEP permits after their municipal approval. So that one, Dennis, on stormwater management.
Yeah.
Townships have a stormwater ordinance. Can the township grant a variance from those requirements?
If you granted anything, it would be a waiver, but the DEP has a set of requirements, very extensive. I think they're from 2004. The municipality can make our stormwater ordinance more strict than that, but cannot relax it any more than that. And to grant any relief, any waivers from that DEP ordinance, you have to notify the DEP of that. Each town, the municipal engineer has to do something called the annual stormwater report and certification, which is due in May to the DEP. And we have to note any waivers granted by any of the boards to the stormwater ordinance. As a municipal engineer, I wouldn't want to do that. Unless somebody would have to have a very good reason. And I can't even think of one, but I guess they'd have to have a very good reason for me to grant a waiver or recommend the granting of a waiver.
And I suspect this is honored in its breach more than its following, but variances should only be granted if the town has a mitigation plan in place.
That is correct.
And there's very few mitigation plans in existence, and DEP just changed the rules in March to even make it a little bit, I don't want to say stricter, but some more requirements on granting that variance.
Yeah, I don't think you're going to find a lot of towns granting waivers to the stormwater.
Yeah.
I don't think so.
I think it would probably be going the other way. I think you'll see more towns tighten up the stormwater ordinance from what the DEP standards are.
For the question, this is a question for all of you. Have you noticed any trends in objectionable petitions to the planning board in our area? Or I'm assuming that's applications. Are we seeing sort of more applications that have more problems in recent time, or is it sort of same old, same old?
Depends what town you're in.
Yeah, like Hopewell Borough is in pretty good shape. It's pretty little, it's pretty developed. There's not a lot that can come in that will be shocking or horrifying. Bigger towns with more open space have a lot more threats.
Well, I'll tell you, like, we'll use Hamilton as an example, not to pick on Hamilton tonight, but you know, if you look at the zoning, take Yardville as an example. It's all residential zones, but there are, you know, Wildflowers 2 is right next to somebody's single family home, and there's a garden center right next to a single family home, and there's a warehouse next to a single family home. So you tend to, in towns where, let's say the zoning hasn't been looked at carefully over an extended period of time, you get a lot more of that conflict, and the application might make sense in that, you know, say Yardville as a mixed use area of Hamilton is going to continue to have a mix of uses, and it's on a state highway and some other things. But that's really where you get to see those types of applications that are, you know, objectionable for the most part, where zoning is a little out of sync with what's on the ground.
I have another perspective on that as well. And I think that, you know, what we have left in terms of open space, I think the lands that we have left are, you know, were not the first choices to develop. What we have left is largely encumbered by wetlands and other sensitive environmental features, high water table, you know, various and assorted environmental constraints. And so I'm in Ocean County, and I see that a lot of the sites that are up for development all have some kind of fairly significant constraints associated with them, because all the developers took all the good, easy stuff to develop first.
Yeah, and I'm seeing in a lot of the towns that we work in, and our municipal client base is mostly Hunterdon County and Warren County, we are just seeing constant applications for warehouse development. Even in residential zones along 78, that's really the trend right now is for warehouse development. So,
so true. You are right. It's like, I hope Amazon stays in business, otherwise we're going to be.
Well, if you look, I mean, even Hamilton has seen, you know, Hamilton has a lot of areas that are already zoned for warehouse. They have a lot of industrial zones where warehouse is permitted, and you're seeing a lot of activity in those zoning districts, you know, for warehouses of all sizes.
And we did find when CVS did apply to be in Hopewell Township in a residential zone, learning a lot about CVS, they are super aggressive, and they will put themselves anywhere they see a state highway with a stoplight. So that is going to continue to be an issue.
All right, here is another question. If zoning allows a gas station, but an aquifer runs under the site and to water wells, neighboring properties, so there's, you know, wells fed by that aquifer, and there are wetlands and a stream on the property, and that stream runs to a Category 1 waterway, is there a way to defeat that before the planning board? So I will take a very quick stab. Category 1 is a special classification of streams in New Jersey that require a 300-foot buffer on either side. There's ways to, you know, build within that buffer a bit, but that should be fairly strict. This question really presumes that it's zoned for a gas station, but there's obviously concern for leakage into the aquifer. Are there sort of things that someone could look for, point out to the planning board of why this is a problem?
Is there a stream buffer conservation zone in the town?
Yeah, so towns will sometimes have their own stream corridor, which may be stricter. I'm not sure there's many towns that have stricter than 300-foot C1 buffers, but towns will have that. And like Cranberry, you would have to get a variance to build within that buffer, independent of any DEP approval. So that's a good point, Michelle.
The
Anyone
other
else?
thing to look at, particularly with gas station development, is wellhead protection areas. So, you know, if there's a community or public water supply well, they have these areas that they define around that well, and DEP regulations do not permit subsurface petroleum tanks within certain, so it'll be like a 1 year, Dennis, I can't remember, is it 1 year, 5 year, 7 year, something like that?
Actually, I'm not familiar with that, Jim. I don't know.
Okay, so there's certain zones that surround a well, and it might not be a residential well. It might only be a community water supply well. And you know, this issue came up in Clinton, in the town of Clinton, where we're the planners. Someone wanted to put a quick check on Route 31, but the town actually has a public water supply well that's within, I think, 750 feet. And if you look at the regulations within certain zones there, you cannot put subsurface gasoline tanks within that wellhead protection zone.
Mhm.
So that's something to look at. If you go on the NJDEP website, or if you just Google, let me figure out what it is. It's NJDEP. What's the mapping program?
GeoWeb. So if you Google NJ GeoWeb,
Yeah.
right, NJDEP GeoWeb, I was going to talk about at the very end. There's a tool, NJ Map 2, which Rowan put together. Has a lot of the same sort of features, so you could see streams, wetlands, forests, these wellhead protection areas. And NJ Map 2 tends to be a little more user-friendly, but GeoWeb has a lot of information if you can work your way through that. You know, if it's not allowed in the zone, so the gas station is not a permitted use, it's not before the planning board, you obviously have a lot more tools.
That'd be a good particular suitability case, wouldn't it?
Yeah, and we defeated a gas station. They wanted a variance, and the property was bounded by 2 streams. So we got the zoning board to agree that it really wasn't suitable. And one of the things we did to look at it, you know, was a gas station quick check. And the planner talked about how it was so suitable for this area and how it was going to meet the needs. There was a quick check gas station like 1.5 miles north on the same exact road, and a gas station, quick check 1 mile south. And I don't know that actually swayed the board, but I was able to put it together on a map and show, really, there's no other options. How is this really necessary in this zone? But that was before the zoning board. So let's see. Any other questions? So, we are just about at 8 o'clock, and, I'm willing to stay on and answer some more questions, but let me just pose one last question based upon one of the questions here to each one of you. In your years of experience, has there been, one good strategy, one thing that really happened at a meeting that really said, wow, and really turned the tide, really was effective in getting across the point from the public?
I'll dive in first. I think that one of the areas that I found to be the most productive in terms of being able to defeat an application had to do with very simple, basic principle of engineering and planning, and that is to locate the seasonal high water table. And prepare yourself, make sure you look at everything, but it is like the foundational design element that should exist for the entire stormwater management system and for so many aspects of the development. And it's like a very simple thing, and it is very frequently ignored, and it can be quite effective when a board finds out that, the basements are going to be filled with water and the stormwater systems all have to be designed based on where that is. So I just found it to be a very effective, very meaningful, and very real tool to look at.
That should be one of the first things that the designer does.
Yeah, and that's your hint to an application too, because you'll see a backhoe in a field with a bunch of holes.
Yeah, that's a pretty easy one to determine the seasonal high water table, even when it's not in the wet season, just by looking at the soil. So,
Well, I had a couple with that, Dennis, that I was absolutely fascinated by. But you're right. When you don't do it in the season and they look at the soil modeling conditions,
yeah,
a lot of professional engineers are very, very, they need to steer around that because it makes the site design too difficult. So I've had, you probably need a really good engineer if they start fooling around with modeling. But it's one of those areas that I have just found that it really needs to be looked at. It should almost be like front and center on design.
yeah, I agree.
I think, Mike,
You're a good engineer.
one of the things that I've seen pretty frequently, more working as a planner on a private job, is questions about traffic studies, when they were done. Was school in session? Was school on spring break that week when they did the study? It's important to focus because a lot of times, traffic impacts are what people are most concerned with. And with a conforming application, a board can't necessarily deny it because of traffic concerns. But particularly on a use variance application, say for something like a gas station with a convenience store, this comes up down the shore a lot. I'm sure Michelle's heard it before is, okay, well, did you do the traffic study during the summer when everybody's here, or did you do it in January when, nobody's here? So it's important to focus on the time frame for the traffic study and ask those questions, particularly on a use variance. I think it's helpful because traffic is something that the board can consider as an impact in a use variance situation.
Right, in a use variance, very important distinction.
Really good point.
Yes.
And so every planning board member or zoning board member is allowed to go visit the site and is encouraged to do so. But I'll tell you that a lot of them don't have time and don't do it. So very often the photograph from the neighbor shows a very different perspective than the photograph or the renderings from the applicant. So that's a really helpful thing for the board to see, especially if they haven't had a chance to go out and visit the site themselves.
Absolutely.
Now, I guess mine would be the things that kind of surprise me is I get a set of plans, I understand the plans, I see the survey, and I take a walk out to the site and I find out that there's, a big field of gravel behind the building where they said, that was not there. And I find out that the survey's 9 years old or, but something's inaccurate. And the site visit to me is essential.
Yeah.
For sure.
All right, I'm gonna, if anyone else, I try to get as many questions as possible. I don't know if there's ones I've missed. If I did, please pop them back up. And, then as you mentioned, sometimes what the plans show and what the site shows are a little bit different. One thing I've seen several times, and this is sort of nuancy, but not, when you do stormwater management, you're supposed to show that the site can infiltrate. So you do test pits. Those test pits are supposed to be where the basins are. Sometimes they're not. I've seen one or two where test pits were at the highest point of the site. So that they were able to show that what Michelle said was the seasonal high water table. You can't have stormwater management that sits in there. So if you take your test pit at the highest point of the site, you're less likely to hit it. I've seen that a couple times. So not only was it nowhere near where the stormwater basin should be, it was artificially inflated. So,
I would ask, folks come in and at times and get their approvals, and one of the conditions are you have to do dry wells. And one of the conditions should be that if they don't have they don't have testing at that site, which shows on the survey that they can do it in front of the engineer, and we can go out and prove that it's there. Because it's not going to do any good to have a dry well when the seasonally hot water table is a foot below the surface or 2 feet below the surface.
Yeah, and I would argue, and I have argued, that those things can't be left to afterwards because they can dramatically change the stormwater management system.
Yes.
And the planning board is obligated to determine, or the zoning board is obligated to determine that system works. So all of those things, at least I have argued, have to happen ahead of time. That has to be on the plans. It has to be there, and the board has to look at it and say, yeah, we think that works and that meets the standards.
Right, and a lot of times a board will say, look, this has to be done, and it has to be reviewed and done under the supervision of the township engineer, and that means if it's not and it doesn't pass, well, that part of the resolution isn't met, so we're stopping, we're all coming back, and we're going to reassess the situation, and that's where it helps to have a township engineer like Dennis.
Yeah. Well, they're taking a huge gamble by doing it backwards like that. That's
Yeah,
Yep.
that's on them, but that's on them.
square one. That's not a good thing.
Right, and it's like too much delegation. Boards are allowed to delegate aspects of their decisions, but there's a line of cases that refer to fundamental elements of the plan. Things like stormwater management, sanitary sewage treatment, and those kind of things are very difficult to be put off as conditions subsequent that then get resolved outside of the public forum. And I just find myself increasingly amazed at how inventive some engineers can be about such a simple thing as where's the seasonal high water table.
Mm-hmm.
Yeah, there was a question about karst. Dennis?
Karst features, K-A-R-S-T?
Yes.
Yeah.
Oh, my favorite.
Dennis, you want to just briefly describe karsts and...
Actually, no, because I don't.
You don't...
That's not in our territory here.
I can actually cover
Okay.
that. Mike. A lot of the towns that we work for in Hunterdon and Warren have karst, and it's basically it's limestone features that are subsurface, and it comes with, it's really, we have checklist items in our ordinance that require applicants to identify the extent of karst features. It creates issues for structural stability, but a lot of times there are engineering solutions. If a sinkhole opens up on a site, it can be grouted with cement, and there's different things you can do. The other limitation that it presents is in stormwater management and infiltration, because the DEP does not want you to infiltrate stormwater in karst features because it dissolves the limestone. Then you have a tendency to get more degradation and more sinkholes that open up. So there's a bunch of different considerations with stormwater management, in particular when you have karst features. And it can be, the geographic areas that can be underlain by this are pretty broad. So, it's pretty routine that I'll drive through some of our Warren County towns and you'll just see a sinkhole out in the middle of a farm field. They just kind of happen, but largely it's an engineering and design issue for the applicant to address. It can be overcome.
All right. Sorry, trying to see if there's just any last things. I think that is not all of the questions, but most of them. Jim, because I know, and we touched very briefly on this, we were talking about affordable housing and zoning, and so a lot of towns are doing areas in need of redevelopment. And again, that's probably an entirely separate webinar.
It is.
Which I'll be more than glad to try to figure out how to put together. Could you just very, very briefly, and Mary Lou, sort of talk about what that is? And is there a way to stop that process?
There is, and I'll tell you, I'm involved in a case for one of the communities that we work in where someone's challenging a redevelopment designation that we put in place. So the local redevelopment and housing law in New Jersey allows municipalities to investigate certain areas and determine if they are in need of redevelopment. And there is a set of criteria, A through H, that law sets forth. And I, as a planner, when I assess an area in need of redevelopment, I judge it against those criteria. And really what that law allows you to do is if you designate it, you can have like almost a self-contained planning process. It almost allows you to spot zone, really is what it is. So a lot of towns use it. The other thing is it opens up some financial tools, mainly pilot programs, so long-term tax exemption programs, short-term, 5-year short-term tax exemption programs that will help a community incentivize or entice developers to develop, sites that need to be redeveloped. But, you can use it on greenfields too, because if a property's been vacant for an extended period of time, that's also one of the qualifying issues for an area in need of redevelopment designation. But you can fight it. I had an attorney cross-examine me for 3 hours over 2 meetings on my report on that particular issue. So just like an application that's approved, you can file an appeal with the court. You can do the same thing on a redevelopment designation. You do have a means to fight that, but within a certain period of time. Again, I think there's statutory time limits. So you have 45 days after the decision's published for a zoning board case or a planning board case. I think it's roughly the same for a designation of an area in need of redevelopment.
But there's a process. It's either generated by the town council or committee and then reviewed by the planning board, or the planning board starts it. There's a report. There's a process which may or may not provide public input.
It does. So the planning board or the land use board is the body that holds a public hearing on the investigation. So there's a public hearing where most times I prepare a report. You don't really have to prepare a report. You can just have a map and then you can just discuss the criteria. So that will be part of a public hearing process, and people can come in, ask questions about that, raise points for consideration. At the end of that hearing, the planning board makes a recommendation to the governing body via resolution. The governing body is the only body that can designate an area in need of redevelopment. But a lot of times they'll delegate the investigation process and also the development, redevelopment plan. They'll delegate that to the planning board as well.
Great. All right.
Question I just want to make on that, and you can't just have 10 years of vacancy.
I know there's other factors. I didn't want to get too deep into it, Michelle. It's
Gotta
already 8:17.
Yeah.
No, understand. Okay, just
There is, I think we've got 3, maybe 4 different webinars out of this, just one.
Yes.
So
That's a whole one. Sure.
It is 8:17. I do want to thank everyone who attended, all of the questions. I hope I got to all of them. If I didn't, please send them to me. I will see if I can answer them independently. All of you panelists, thank you very much for your time, your experience, your knowledge. This has been helpful. I have learned quite a bit. So I do appreciate that you have given us the benefit of your wisdom.
Thanks for having us.
So with that, thank you. And just everyone, again, appreciate it. We're going to send you a survey. Please answer it. If you have additional topics you want us to try to put webinars on, we are in the era of webinars, so we'll be more than glad to try to put it together. And just one last, I just want to reiterate, the whole planning and zoning board process is public. You have the right to go look at files, whether that is physically down in the municipal building, which is not really possible nowadays, or virtually. They have to be available to you. You have a right to look at them. Email, call your planning board or zoning board secretary, figure out how that is working nowadays. And so you can get that information so you could figure out what you need to do. And so with that, again, thank you very much. Good night.
Thank you, Watershed. Thanks for doing it.
Yeah.
Thank you.
See ya.
Thank you, everyone. Bye.
Night.
Night.